Can I get an emergency order in my divorce? It all depends on whether the court believes you have an emergency or not. An emergency usually requires that a person is going to be permanently harmed and that any time factor that's involved will create a greater likelihood that a person will be injured or damaged in some way. The other factor is whether it's an immediate danger to that person. Otherwise, what the court is most likely to do is to schedule a hearing. That hearing might not be for a week or two. It all depends on the judge's schedule. It depends on which court you're in. Every court is different in how they schedule court hearings. But you always can ask a court for an emergency order before you even have a hearing. If a court grants an emergency order, it's most likely that there is going to be a hearing that follows. Depending on the nature of the emergency, a judge might expedite a hearing. Every case is different, but you really do have to have an emergency. If it's something that can wait and nothing is going to happen, or it's something that can be undone a week or two later, then the court is probably not going to grant an emergency order. If you think you have an emergency, you need to discuss that with your attorney so the attorney can work with you to determine whether the facts are appropriate and whether that emergency request needs to be filed with the court as soon as possible.